this is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for watching this short episode on Toeic, which will concentrate solely on appeals and hopefully what makes a winning appeal. Obviously, every case turns on its own facts, but having done so many appeals recently, I thought I would share my thoughts. For those that do not know, Toeic was an English examination accepted by the Home Office for individuals seeking to establish that they could speak English in order to obtain a visa. And unofficially, for those that work in the field of immigration and more widely given the media exposure, it refers to those cases where individuals had their leave curtailed on the basis that they had cheated and their tests had been cancelled following a panorama programme way back in February 2014 that showed that some colleges were cheating, i.e. people had paid other people to sit the tests for them. This led to ETS, the company that ran the tests, to cancelling a huge number of test results, which led to the Home Office issuing decisions to remove. I intend to do a longer episode with further examination and discussion of the law at a later stage, but today just want to talk about the appeal itself. Following the cancellation of the tests, as I said, the Home Office issued notices that informed those affected that their leave was curtailed and that they should leave the United Kingdom immediately, and if they wanted to appeal, they could appeal from abroad. Without boring you with the unnecessary law, the court found that the material produced by the Home Office gave rise to a case to answer, but an out-of-country right of appeal was not a sufficient remedy. That's the law in a nutshell. In short, it is for the appellant to show that they actually set the test, and that will be the issue on the day of the appeal. Turning to the appeal itself, firstly there's a preliminary point to make, which is, as I've touched upon, it is for the Home Office to produce evidence that there was actual cheating. If the Home Office do not provide any evidence that relates to the individual, then, and such evidence can often be called the look-up tool, more of that later, then the appeal should succeed arguably on the basis that there's no case to answer. And I've had appeals allowed on that basis. So it's always it's important to check on what, if any, evidence the Home Office intends to rely. As to the issues at the appeal, the Home Office generally relies on the following arguments. I say generally, as no two appeals are the same. The first argument that the Home Office will rely on is that the generic material, and often coupled with the look-up tool, which is a document provided by ETS confirming whether the test was invalid or questionable, is enough. As I've mentioned, look at the documents carefully to make sure that they refer to your client and see if there are any other documents that are handed over that also help the client. I've had cases where the look-up tool refers to another individual entirely, which has led to the appeal failing. Another particular topic for the Home Office is why was a particular test centre chosen? This might sound odd, but I've had clients who live in Manchester sit tests in Portsmouth. It's important that this is addressed because this can look a little odd as to why someone's travelled the length and breadth of the United Kingdom to do a test that they could have done round the corner. There'll usually be detailed questioning on the day of the test itself. I'd be surprised if I could remember what I was doing 7 years ago or 8 years ago, and it's important that applicants and individuals also bear in mind that the test took a long time ago. There'll also be sometimes questioning on the ETS manual itself. I had a case recently where I interrupted the questioning to ask if that was the manual that was in play as at the date of the test. The Home Office couldn't confirm it and the questions were then ruled inadmissible. Another favourite topic is to ask whether the person has ever sat exams before. The reason for this being is that the Home Office would say that The individual may now be able to speak English and could speak English, but they were nervous and so therefore paid somebody to do the test. Occasionally, the Home Office rely on something called Operation Facade. Operation Facade was a criminal investigation into certain colleges. Check the date. A lot of the dates that I've found relate to May 2015, and there's no further updated evidence. I usually point out that if an appellant sought to rely on 4-year-old evidence, little weight would be given to it. I have never yet, having questioned the Operation Facade report, been given more up-to-date evidence. I find that appeals succeed most where the appellant can produce detailed evidence that they could speak English before the date of the test. This is vital. I cannot stress it enough. Examples include: did the client go to a school where the medium of practice teaching was English? Did they pass O-levels and A-levels? If so, UK NARIC can verify them, and they ought to be verified and produced. Have they completed a degree or other qualification before coming to the United Kingdom? Again, get UK NARIC to verify it. Have they done an IELTS? This is another English language test that hasn't been impugned before coming to the United Kingdom. This is another important piece of evidence. Did they have any work experience whilst they were abroad? This is also important, as I've had individuals that have worked in call centres and were able to produce evidence that they worked in a call centre and used English to speak to people in England. If they entered the United Kingdom as a Tier 4 student, what evidence did they have to show the college to ensure the college that they could speak English to the sufficient level? Also, what exams had they passed before they took the Toeic test? This is, as I say, a summary of the earlier points. Also, what were they studying as at the date of the Toeic test? I've had clients take the Toeic test in February and be awarded an MBA in May. This would make them an exceptionally fast learner if they were cheating. What other English exams have they set? Have they worked in the United Kingdom? If they have references from employers confirming that they've worked, then these should also be produced, vouching for the fact that they could speak English and that they were a good employee. Further, any other involvement in life in the United Kingdom? Did they play football or cricket? Were they involved in any charities? And also, what experience have they had in sitting exams? Did they sit O-levels, A-levels? Did they sit exams for their degrees? Oh, and finally, if you can't remember exactly how many Cocoa Pops or slices of toast you had on the morning of the test, it's okay to say you don't remember. While court can be terrifying and you might feel like you have to give an answer, be honest. These are tests done 7-8 years ago. People's lives have moved on, they have married, they've had children, they've lost people, and perhaps disturbingly have been put through some 4 years of litigation and uncertainty as to their immigration status. In my closing speech, if the individual can show that they had a good command of the English language as at the date of test or well before, it is a good indicator that they did do the test, and therefore the Home Office will struggle to win the appeal. All of the above points will give any case a better chance of success if they are followed. The last word of caution is that any and all documents should be included in a properly indexed and paginated bundle and served along with a detailed skeleton argument setting out the facts and law of the case in line with the tribunal rules. This is exceptionally important given one of the earlier broadcasts as the tribunal have taken to relying on Rule 11 and adjourning or cancelling appeals where the bundles have been filed late. This can be a disaster for the individual who has often been waiting many years for the attempt to clear their name. Often these refusals go back to 2015. Now, I think I've covered pretty much everything that makes for a winning appeal. If you have any further questions or you have an appeal coming up, or you have a refusal, please do not hesitate to get in touch with your lawyer or get in touch with me, Paul Turner, the immigration barrister, on 0207 242 3488 or clerks@imperiumchambers.co.uk or at my website, theimmigration.barrister.co.uk. Thank you very much for watching. This has been Paul Turner, the immigration barrister at Imperium Chambers.